Good afternoon, everybody. And welcome to join us for the first instalment of the National Consumer Law Seminar Series in 2021. This seminar is held in conjunction with the Federal Court of Australia, the Commercial Bar Association of Victoria, the Victorian Bar and Monash University Centre for Commercial Law and Regulatory Studies. We are looking now at the reflections on the 10th anniversary of the Competition and Consumer Act 2010. In a decade since the commencement of the Competition and Consumer Act, competition and consumer issues have gained prominence in an ever-changing world. We're about to hear from an expert panel with significant experience in administering, advising on and resolving disputes under the Act. They'll share their vast experience and give expectations of the next decade in the operation of the Act. Rod Sims and Neil Young need no introduction. Rod Sims was appointed Chair of the Australian Competition and Consumer Commission in August 2011 for a 5-year term, reappointed for a further 3 years in August 2016, and now a further 3 years until July 22. Had extensive experience in the business and public sector. Immediately prior to his appointment to the ACCC, he was Chairman of the Independent Pricing and Regulatory Tribunal of New South Wales, Commissioner of the National Competition Council, and was also a Director of the Port Jackson's Partners Limited, where he advised the CEOs and boards of some of Australia's top 50 companies on commercial corporate strategy over many years. Neil Young has had experience extensive experience in appellant and trial practice in constitutional law, commercial law and corporations law, trade practices, banking, securities, trusts, equity, intellectual property and taxation. He was appointed Queen's Counsel in November 1990 and was a Justice of the Federal Court of Australia from 2005 and 2007. He has appeared in, if not most, if not all jurisdictions in the Commonwealth of Australia. Mr. Sims is going to be starting his presentation. I just wanted to inform you that at the end of the presentations of the speakers, there'll be an opportunity to ask questions. We'll be on limited time, but there'll be about hopefully 15 minutes for any questions that need to be asked. I would ask that if you do want to ask a question, please identify yourself on the chat availability, and who, if you have a particular person you want to ask a question of, to identify that person, please. So I will now hand over to Rod Sims.
Thanks very much, Justice Middleton, and it's a delight to be here with you and Neil Young today. And thanks very much to Monash University for inviting me to speak today. And what's really exciting is, I mean, it is absolutely worth celebrating the just over 10 years milestone that was the commencement of the Competition and Consumer Act, a milestone in legal history and a milestone in economic history. The transition from the Trade Practices Act to the CCA, which of course incorporates the Australian consumer law, heralded a new era in Australian consumer protection. This was signalled, of course, by the very renaming of the TPA to the Competition and Consumer Act in 2011. By including the word consumer in the title, it really put consumers in their rightful place at the centre of our regime. Of course, we have to acknowledge the inception of the Trade Practices Act over 4 decades ago. The TPA has long served as a powerful instrument in ensuring the proper functioning of Australian markets. Like most legislation, however, perhaps all legislation, the TPA has had to be continuously updated to ensure it meets the needs of a changing marketplace, new and emerging business practices, and growing consumer expectations. For these reasons, prior to the introduction of the CCA, there'd long been a call to overhaul the Trade Practices Act to better serve the needs of consumers and small business, which is really important. This call gained a lot of momentum during the late 2000s, which resulted in the federal government directing the Productivity Commission to conduct an inquiry, and they released a landmark report in 2008, which recommended extensive reforms to the consumer protection regime. The government moved very quickly and implemented the Commission's recommendations through COAG, federal, state and territory governments, and they worked very efficiently and saw the legislation commence on 1 January 2011, as you all know. I think it's worth noting that the General Manager of the Competition and Consumer Policy Division of Treasury said at the time that this was the largest overhaul of Australia's consumer laws in 25 years. What's important about that is the General Manager at the time was Stephen Kennedy, who's now Treasury Secretary. So it's nice to see that continuity of involvement in these sorts of issues by the Commonwealth Treasury. There'd been previous attempts to unify the consumer law over time, but those attempts were often ineffective for a range of reasons. In my view, the ACL reforms, like the earlier HILMA reforms and national competition policy reforms, stand up to and actually rival the many major microeconomic reforms that we all think fondly back in the 1980s and 1990s. The introduction of the ACL was a major reform. And I'm going to explain that today by firstly just looking at the nature of the Australian consumer law, secondly, the significant outcomes that it's delivered, and thirdly, some of the lessons we've learned along the way, including what further changes might now be required. So topic one, the game-changing nature of the ACL. It really can't be overstated. Prior to its introduction, Australia's general consumer laws consisted of 13 separate acts providing for consumer protection across Australia. In addition, there are another 8 state and territory laws about the sale of goods. The introduction of the ACL replaced at least 850 sections in these acts, not including many of the ancillary enforcement and other provisions that supported them. So that was a significant change in itself, just bringing the law together. But it also saw a golden era of collaboration between the consumer law regulators. By introducing for the first time a single national consumer law, the ACCC and its state and territory counterparts have been able to collaborate far more easily on issues of consumer concern. And a great example of that was last year, the collaboration that was evident during the COVID pandemic, with ACL regulators establishing an urgent response group to deal with the deluge, and it was a deluge, of consumer issues that came from the pandemic. Of course, we focus on national issues of interest to consumers. Other issues are more appropriately addressed at a state and territory level. So that really works out well when we cooperate and chat amongst ourselves as to who's best to deal with things. It's not always one way, however. Many state ACL regulators have taken and continue to take the lead on nationally significant enforcement, compliance and policy reforms. So it's really had a major gain in terms of collaboration. The key change made, however, was the introduction of civil pecuniary penalties for consumer law contraventions. It's transformed our armoury in relation to enforcement action. Therefore, it's transformed compliance with consumer laws, because for laws to be effective, there must be serious and effective consequences for breaches of them. The ACCC was also granted the ability to issue infringement notices where it had reasonable grounds to believe that a corporation contravened certain provisions of the ACL. There was much criticism of this change at the time, but the sky hasn't fallen in. I'd like to think most people would think we've exercised very careful judgment when it comes to the exercise of this power, and it's worked as intended. The reforms also gave us the power to issue public warning notices to alert consumers of a suspected breach of the substantive provisions of the ACL. And look, in many instances, the rights and obligations of rights of consumers and obligations of manufacturers weren't new, but there were new regimes introduced. For example, the consumer guarantee rights and the unfair contract terms provisions were new additions, particularly important when the unfair contract terms provisions were extended to small business. The CCA also imposed a nationally consistent approach to product safety, including mandatory safety standards, product bans, product recalls, mandatory reporting and notification requirements, and this has transformed our ability to deal with safety issues. So massive changes there, which I've in a sense rushed through, but the combination of bringing the law together and putting in all those changes was just a fantastic change. Let me just talk about measuring the impact of the Australian consumer law. So it's in a sense, the biggest change in one way is the consumer law can now be considered as equivalent to competition law in terms of its significance. It's no longer the poor cousin that I think it's been for way too long. If you think back in the past, in the absence of civil penalties, the ACCC relied on either obtaining injunctions and other remedial orders or pursuing criminal prosecution by the CDPP in obviously rare cases, which meant that outcomes for consumers were often less effective, or in the case of criminal actions, necessarily slow, difficult, and often impractical. With significant civil pecuniary penalties, we can now pursue breaches by large, national and sophisticated traders and individuals and ask the federal court to impose substantial penalties of an appropriate deterrent value. So we're not only penalising businesses for non-compliance, but, and this is the key point, we're deterring other businesses from engaging in similar misconduct. In my strong view, having well-intended laws that are hard to enforce is frankly corrosive to society. So fortunately, the ACL corrected this in those fantastic reforms over 10 years ago. Significantly, just as one illustration, the federal court has imposed a total of almost 400 million in civil pecuniary penalties instituted by the ACCC in the last 10 years. That's 400 million. That includes the Volkswagen and Viagogo penalties, which are both currently under appeal. That only 5 million in criminal fines was obtained for consumer law breaches prior to this reform absolutely says it all. In contrast, the ACCC's power to issue infringement notices has enabled us to deal with a whole lot of less significant matters without resorting to court action. This avoids tying up significant resources on litigation, yet still delivers good and very timely deterrence messages. We've issued a total of 281 infringement notices against 140 businesses over the last decade. The CCA reforms also gave us the ability to seek appropriate orders to deal more effectively with rogue individuals, and there's a lot of those out there who wind up companies and set up new corporate entities in an attempt to continue misconduct. For example, the ACCC can seek the court to seek that the court impose a disqualification order to prevent an individual who's worked or knowingly concerned in a contravention from managing corporations for a period of time. The ACCC is also able to seek more bespoke orders, banning individuals from managing corporations or engaging in specific forms of conduct. This recently occurred in our case against We Buy Houses. In that matter, in addition to the business, Rick Otten, obviously an individual, was further penalised $6 million for his involvement and banned for 10 years from managing corporations as a result of his misconduct. The use of public warning notices has likewise been effective in terms of warning consumers about companies phoenixing, for example, in the matters involving Luxstyle and Dismissals Direct. we judged the issuing of public warning notices was the most effective and fastest way to take action and prevent further detriment to consumers. We've also got consumer redress orders, which can be used in appropriate circumstances. The totality of these reforms, which all resulted from the introduction of the ACL, has just improved a new and improved way of working for the ACCC and for consumers and for the economy. It's brought meaningful outcomes, and I just want to dwell on three in relation to Coles, Volkswagen and Telstra that I think are worth highlighting. The Coles unconscionable conduct case in 2014, to my mind, represents one of the most important results delivered by the ACCC under the ACL on behalf of smaller business suppliers. It's one of the first findings of unconscionable conduct in a business-to-business context under the ACL. In my view, Coles' behaviour was simply dreadful and needed to be strongly dealt with, and it was. In addition to the penalty of 10 million imposed by the court, Coles agreed to a redress process via a Section 87B undertaking, as a result of which Coles refunded more than $12 million to suppliers. This was a major matter that dominated headlines for about 18 months. The outcome in Volkswagen is also important. It's delivered the highest ever penalty of 125 million imposed by the federal court. We're now awaiting judgment from the full court following an appeal against this penalty. Finally, our recent institution of proceedings against Telstra for engaging in unconscionable conduct in selling postpaid mobile products to Indigenous Australian consumers is another significant matter. It's still before the court, but the ACCC and Telstra have agreed to jointly submit to the court that a penalty of 50 million is appropriate in all the circumstances to achieve specific and general deterrence. So my final topic about the CCA not standing still. The CCA has continued to evolve. You've got, for example, significant reforms following the Harper Review. Not only did we see the removal of the per se prohibition for exclusive dealing, the introduction of class exemption processes to allow collective bargaining. They were important developments, but of course they were completely overshadowed by the amazing debate which we had about the misuse of market power provision in Section 46. While I did appreciate the concerns raised by many, we felt there was a clear case for reforming the misuse of power provision. It clearly was no longer workable, and we needed to send messages about the importance of protecting the competitive process. Our first proceedings using the new Section 46, the Tasports case, is listed for hearings in a few months. The last 10 years haven't just been about the ACL. You've had new industry codes of conduct, for example, in horticulture, electricity, retailing, dairy, and numerous iterations of the franchising code. So these changes touch a lot of sectors. We've also made good progress over the past 10 years in enforcing consumer guarantee and unfair contract terms regimes. However, we need further change. We basically need change so that failure to comply with consumer guarantee and unfair contract provisions are contraventions of the ACL and subject to penalties, which they're not now, and we're working with federal and state governments in a review of these provisions. Now, when I first started with the ACCC in 2011, and obviously I got my timing pretty good in coming when the ACL arrived, there was genuine excitement about the imposition of any civil pecuniary penalty of $1 million or more for a consumer law case. However, as time passed, it was absolutely clear that the penalty regime for ACL breaches needed an overhaul if we were going to defer future misconduct. The ACL reforms in 2018 led to a significant increase in maximum penalties, which is something that the ACCC actively sought and is extremely proud of. The higher maximum civil pecuniary penalties for contraventions of the ACL means they're now the same as the maximum penalties for competition law provisions. And again, I'm proud to say that as far as we are aware, Australia's civil pecuniary penalties are now the highest in the world for contraventions of consumer protection laws. Now, I might just mention very briefly our criminal cartel work. It would be remiss of me not to do that. We advocated for criminal penalties for hardcore cartel conduct, and in July 2009, these reforms commenced. The detection, investigation, and ultimately prosecution of criminal cartels is very hard work. We've now got a dedicated team that's doing that, and while progress was initially slow, we think we've really now hit the ground and are running quite hard. We just finished our international shipping cases, 3 cases that overall saw penalties of 83.5 million. In the case against NYK, they were fined 25 million, K-Line 34.5, which remains the highest, the largest criminal fine penalty ordered under the CCA. And in February this year, we had the final case where Walleninus Wilhelmsen, I'm sure I've mispronounced that, was fined 24 million for its part in the cartel. And of course, we've got a range of other cartels currently before the court. Let me just quickly finish up looking forward. Despite the progress we've made, the ACCC will continue to advocate for reforms to address key issues affecting consumers and small business. Indeed, a 10-year anniversary is a good time to reflect and take stock. We find that reforms often occur in 10-year cycles. I've already mentioned our view of the need for change in both the consumer guarantee regime and the unfair contract terms regime to make such conduct illegal. It's our view Australia needs also an unfair trading practices prohibition. This was identified in the review of the ACL in 2018. I'm personally convinced that such a prohibition would actually remove or avoid the need for more intrusive industry-specific regulation. It can actually reduce the regulatory burden. We often find there's problems found. People look for solutions that are specific, that are industry-specific, quite intrusive. If we had an unfair practices provision, I could think it could prevent a fair bit of that. We're also advocating for general safety provision to be introduced to prohibit suppliers from supplying unsafe goods. On the competition side, we're also considering reform to the merger control regime. Merger control plays a critical role, obviously, in ensuring that competition is not eroded via mergers. In recent years, as people are aware, the ACCC has become increasingly concerned as to whether our merger control regime remains fit for purpose, and in particular, whether it's achieving the balance required to ensure good outcomes for consumers and the economy. Increasingly, we believe that merger parties and the courts are focused on what is likely to happen in the future without the acquisition, which is very challenging to prove in court. While this is a relevant consideration, it's also open to manipulation, and the focus on the counterfactual, in many cases, we think risks overlooking the likely anti-competitive effects of the merger itself. This is further compounded by many of the merger factors listed in Section 53, which can be used to support merger clearance. It appears that insufficient weight is placed on the risks to competition, such as potential competition being lost, barriers to entry being raised, or competitors being foreclosed. As a result, we believe our merger control regime is skewed towards clearance, which presents real challenges for Australia's economy, given the damage that can be done by anti-competitive mergers. We therefore consider that the approach to merger control needs to be rebalanced, and we're currently exploring options which can bring about this change. Finally, just returning to the ACL, I'll leave you with one final comment. That's to caution against the divergence in consumer law across jurisdictions. We had fantastic cooperation that's delivered many benefits 10 years ago. It's harmonised our laws, led to cooperation. We need that to continue, and we all need to be on our guard that we don't slip back to having different laws in different jurisdictions. That I think would be extremely unfortunate. Thanks very much for your time today. I think I've stuck to my 20 minutes perfectly.
You have, Rod. Thank you very much. Thank you very much for your presentation. We'll now move over to the Honourable Neil Young.
Thank you, Justice Middleton. I would also like to thank Monash University and the other sponsors for inviting me to participate. I propose to canvass some milestones and some significant recent developments in competition and consumer law. I'll do so from the commercial litigation perspective that I am most familiar with. I'll touch upon these areas: cartel conduct, the new version of Section 46, statutory unconscionability under Section 21 of the ACL, and one aspect of the ubiquitous misleading and deceptive conduct provisions. Looking back over the last 10 years, the most significant development was, in my view, the Harper Review. It delivered its final report in March of 2015. Most of its recommendations were implemented by legislation in 2017. The changes that followed have been transformative. Perhaps the most renowned is the change to Section 46, but there were other very important changes. Can I start with cartel conduct? Cartel conduct provisions are directed towards one of the most serious infringements of competition law. They relate to price fixing, restricting outputs in production and supply chains, allocating customers, suppliers, or geographic regions amongst competitors, or bid rigging. There have been relatively few cartel cases to date. I expect cartel conduct will remain a focus of ACCC enforcement policies for the future. Cartel conduct requires satisfaction of two conditions, known as the competition condition and the purpose effect condition. The competition condition requires that the parties to the alleged cartel provision must compete with each other in trade and commerce in relation to the supply, acquisition, or production of goods and services. Now, one feature of that is noteworthy is that the words trade or commerce were inserted in 2017. That followed something, in my view, of a misstart in one of the early cases, Norcast and Bradken. It concerned an arrangement that a Canadian company would make a bid for another Canadian company on the Canadian Stock Exchange. It had little connection with Australia other than the party that was a participant in that arrangement was Bradken, a company incorporated in Australia. The judge considered that the cartel laws did not contain either an explicit or an implied limitation, so that they were confined to arrangements relating to the supply of goods and services in connection with a market in Australia. Bradken argued that that limitation was implicit in the whole structure of the Act. The judge took a different view. Her view was reversed by legislation in 2017 to impose that explicit requirement. The other condition is a purpose effect condition. That essentially requires that the conduct must have either the purpose or the effect, or purpose and effect, of doing the prescribed things, such as price fixing, bid rigging, etc. One of the issues in that regard has been whether purpose is to be assessed objectively or subjectively. The cases have now resolved that a subjective test is to be applied. the purpose condition looks to the operative subjective purpose of the relevant participants in the cartel arrangement. That has been made clear now by the full federal court in a case called ACCC and Cascade Coal, decided in 2019. Now, one other thing worth noting about the cartel provisions is that there is a significant joint venture exception. It's been broadened as a result of the Harper Review to apply to joint ventures for the production, supply, acquisition or marketing of goods. It was previously more confined, and it applies where the arrangement is reasonably necessary for undertaking a joint venture. There is, however, a 2017 provision that provides a safeguard. It requires that the joint venture is not carried on for the purpose of substantially lessening competition. So that joint venture exception is something of real significance that emerges whenever there is an issue about cartel conduct. Now, the other thing I might note about the cartel provisions arises from a case concerned with Section 45. It is ACCC and Flight Centre. In that case, a majority of the High Court, with a dissent by the Chief Justice, Robert French, held that an agent may be in competition with the principal in a market for goods and services where the agent has a sufficient degree of autonomy to act in its own interests. That concerned a travel agent, Flight Centre, that sold airline tickets in competition with the airlines, but also sold tickets on behalf of airlines. But it had a degree of autonomy in relation to the setting of prices when it was selling tickets in competition with its supplier of the tickets. Now, that's a significant recognition of the reach of Section 45. It may have implications for the ambit of the cartel provisions, in my view. Now, if I then move to Section 46, I don't want to canvass the whole debate. Time would not permit that. Most of the listeners and viewers will know that the previous form of Section 46 focused on a taking advantage of market power for a prescribed anti-competitive purpose. The section proved difficult to apply and difficult to prove a contravention. The taking advantage formulation was designed to describe a causal connection between the holding of market power and the prescribed conduct for a prescribed purpose. Unfortunately, the way of measuring or proving that causal link became somewhat problematic because of the way in which a counterfactual test was applied. Now, I remember being in rural press in the ACCC and challenging the narrow application of that test unsuccessfully in the High Court, which is one of the reasons why the Harper Committee thought that it should be revised. Section 46 now prohibits a corporation with a substantial degree of market power engaging in conduct that has the purpose, effect, or likely effect of substantially lessening competition. Now, that's a well-known test in the context of Part 4 of the CCA. But what is noticeable is that the possession of market power has now been rendered somewhat marginal or incidental as an element of the provision. Basically, it attacks unilateral conduct that has the purpose, effect, or likely effect of substantially lessening competition. Now, that's a bit of a departure from European and other analogues in Canada and elsewhere, which retain a provision concerned or focused on an abuse of market power. Despite that difference, Section 46 is capable of applying to all forms of conduct that would be caught by an abuse of market position test. Now, we've had no real decided cases under the new version of Section 46. The ACCC's litigation in Tasports is in prospect, but I expect there will be litigation under this section, both by the ACCC and private parties. There is, for instance, a recently launched case by a company called Epic against Apple. It is going to test the application of Section 46 to the constraints that Apple imposes on app developers and their access to the Australian App Store, for instance. So I expect that provision is going to find increasing use in areas where major players and the technology industry is one, where the major players assert various constraints and restraints to retain control of certain markets. Can I then move to unconscionable conduct? I want to focus not on the unwritten law provision, Section 20, but rather on what's been called statutory unconscionability in Section 21. In formulation, it is intended to extend beyond the reach of what would be known under equitable principles and in common law cases as unconscionable conduct. And at least to some extent, it's been applied that way by the courts. However, the choice of the word unconscionable as the descriptor of the conduct continues to impose limitations on the reach of the provision. That is noticeable in the recent High Court case in Cobalt. And I'll explain that case in a little bit more detail in a moment. Just before I do, can I mention Section 21, subsection 4? It contains some interpretation principles that mark out some of the boundaries of Section 21. It says, for instance, that the section is not limited by the unwritten law relating to unconscionable conduct. It says that the provision may apply to a system of conduct or pattern of behaviour. And it says that courts may consider the terms and manner of performance of a contract in determining whether conduct under that contract, even if voluntarily entered into, nonetheless contravenes Section 21. So that provision is important. The courts have approached the section by considering that unconscionability means something not done in good conscience, but assessed by reference to the norms of society that are in question, both looking at standards throughout society, but also looking at the standards embodied in the provisions more widely of the Competition and Consumer Act. Numerous federal court cases have applied the provision in that way. In ASIC and Cobalt, the litigation took place under the cognate provision of the ASIC Act, but it's expressed in basically the same terms as Section 21 of the ACL. It concerned a shop that supplied Indigenous customers in remote Australia that ran a system of credit under a book system. Aboriginal customers maintained a tab, and the store operator had direct recourse to the accounts of the Aboriginal customers to satisfy the tab. By a majority, the High Court held that the conduct in relation to the operation of that system was not unconscionable. But there's a very interesting divergence between the majority and the minority. The minority considered that the conduct was unconscionable. It comprised Justices Nettle, Gordon and Edelman. They did not favour interpretation of the provision that required a high degree of moral disapprobation, but the majority emphasised the need in applying Section 21 defined victimisation, exploitation or a predatory state of mind. Both Justice Keane and Justice Gageler felt that that kind of limitation emerged from the choice of the word unconscionable. Justice Gageler would step back from the expression moral obloquy that had been used in earlier cases and then disavowed, but he did note that the section was aimed at conduct that must be so far outside societal norms of acceptable commercial behaviour as to warrant condemnation as offensive to conscience. So the majority supports the adoption of a standard that requires some kind of exploitation of disadvantage of a party by another party in a stronger position. Now, that is something of a retreat from the direction in which the Federal Court was headed. It will be interesting to see where the application of Section 21 goes from here. It may be that Cobalt is a case driven by its very special set of facts. There is a very good judgment by Justice Colvin in a case called ACCC and Quantum Housing Group Proprietary Limited from 2020 that analyses Cobalt and its implications, and it repays careful reading. I've gone to these cases about Section 21 because it increasingly figures in commercial litigation as one of the causes of action that is raised, even when parties have entered into a voluntary agreement, but sometimes as a result of the superior bargaining power or monopoly position of one of the parties, which enables it to impose terms and conditions on the weaker party. But increasingly, Section 21 is going to be resorted to in commercial contexts, in my view, although that may depend upon how the Cobalt development unfolds in future years. The last marker I wanted to refer to concerns misleading conduct. There's a recent full Federal Court decision that I would like to commend to the audience. It's ACCC and TPG Internet, the 2020 decision. It dispels a furphy that has been lingering now for a decade as to the test to apply where allegedly misleading statements are made to the public. The High Court in Nike, Campamar and Nike, espoused an objective test, a hypothetical standard that looked to the ordinary reasonable viewer or listener to the statement made to the public as the relevant standard to be applied. That, in my view, is intended to cover the field. That is the only approach. However, some earlier cases had thought that there was a separate test, perhaps an additional test, as to whether a significant number of people in the target audience might have been misled. Now, for some reason, that approach persisted even after Nike. It persisted, for instance, in a case determined by Justice Beach not so long ago. However, the view taken by the full court was this, and I quote, "That significant number test is at best superfluous to the principles stated by the High Court in Cooksu, Campamar and Nike and Google, and at worst, an erroneous gloss on the statutory provision." I expect that will be the view henceforth. And in my view, that's the right position to have reached. Now, that's a pretty quick excursion through some notable milestones. I've only touched upon a few in the time available. That is enough to indicate, I think, that the Competition and Consumer Act is going to remain a central pillar of the commercial landscape in Australia. And it will remain a very significant element in commercial litigation of all kinds of disputes. I think I've almost conformed to my 20 minutes.
Oh, very good. Thank you very much, Neil Young, for that insight. We now have time for questions, and I've just got to make sure I can pick up anything now on chat. Does anyone, oh, we do have some questions, so I will put these through to anyone who has been identified. One question is maybe for you, Rod, when are penalties going to be implemented for unfair contract terms? You're on mute, I think, Rod.
In complying with the orders of the organisers, yes. Look, I think fairly soon. It's been a very long process, but the legislation is moving. There's a discussion paper out. I'd like to think it's going to be this year. There's tremendous momentum behind doing that. I think there's now enough law around so that people have an idea what an unfair contract term is. It's things like unilateral, your ability to increase price unilaterally in the contract, your ability to absolve yourself of any liability under the contract. I think we've got enough case law there now, so it'll be very good when we get penalties, because what happens at the moment is we actually have to take people to court just to get the clause made void, and often on the court steps they can make little changes, and we've spent an enormous amount of time, and we may get change in one case, but we don't send any deterrence messages. So really important we get that, but look, I'd like to think it's going to be this year.
Now, just to show how neutral I am, I'm going to ask this question, which has been put through. Can the panel comment on the suggestion that despite the increase in statutory penalties, the federal court seems to be stuck in a penalty regime which does not really or adequately punish contravening conduct? For example, in ACCC and Reckitt, the contravener made some 26 million from sales of a so-called specific pain relief product, and despite the court's reference to the fact that penalties should not be seen as merely the cost of doing business, the civil penalty imposed was 6 million, increased from 1.7 million imposed by the primary judge, leaving Reckitt some 20 million to the good. The theoretical maximum penalty being 5.9 million sales multiplied by 1.1 million for each contravention was more or less incalculable. So probably that's an answer. That's a question for you, Neil.
It's difficult to comment on the specific case without going back and examining the particular circumstances of that case. However, my experience is that the ACCC is strong, if not aggressive, in seeking sizable penalties. My experience is they are often pushing the envelope of the previously established precedents about the imposition of a penalty. I'm not criticising them for that. I'm saying that you do have that pressure. Corporations, for their part, I think, are usually cognizant that if they're in that sort of situation where there are penalty proceedings against them, they are at risk of having very substantial penalties imposed by a court. my experience of the federal court is that it, more often than not, is more inclined to impose a penalty either at the upper end of the range of submissions or perhaps even above that range of submissions. It's rare that a court will go below what the joint submission is. And often, I think courts are looking to impose a penalty that is sufficiently meaningful that it acts as a real deterrent. So across the broad range of cases that I've been involved in, I would disagree with the sentiment behind the question. I'm not sure I can comment on that particular case, but I would say this, that I don't think a penalty can be set necessarily in a way that recovers the entirety of the profits from a particular type of commerce. It's got to be set in such a way as to be a real deterrent, and that's the better standard to apply.
Thank you, Neil.
I might just, if I could, just make one comment.
Yes, of course.
In addition to accepting the compliment from Neil about being aggressive, I think that case was a bit of a turning point in the sense that there was a recognition that penalties needed to go up, and that was a recognition that we gained out of that. I can't speak for the courts, but certainly that helped us push for higher penalties. I think secondly, it's significant that you've now had, I know it's under appeal, but Volkswagen 125 million, Telstra an agreed penalty of 50 million. That's still before the court, so I accept we haven't had final court rulings on both of those, but that's under the old penalty regime. And now we have in place a new penalty regime where the penalty's gone from 1.1 million up to a maximum of 1.1 million to effectively the higher of 10 million or 10% of turnover. So I think penalties are only going one way, and I think they are tremendously important for wider deterrence. Sorry to jump in, Justin.
No, not at all. Thank you. There is a question directed to you, Rod Sims. The comment is, I found your discussion of future reforms interesting. I'm curious to know, in your opinion, what will be the post-pandemic competition and consumer law landscape look like? What are some of the changes you anticipate as a result of the pandemic, if any?
As a result of the pandemic event, I'm not sure because I don't know. I mean, obviously the issue of travel refunds has been just a huge issue where the consumer guarantees didn't apply and the ACCC had to look at the terms and conditions of just innumerable travel arrangements. And that's taken a hell of a lot of work. So whether the government wants to think about schemes that they have overseas where when you get a pandemic, there's some automatic scheme coming into place. I'd like to think the pandemic will help push the need for consumer guarantees to be illegal, for unfair practices also to be made illegal. I realise that's a long debate. It obviously feeds off what Neil was talking about with the unconscionable conduct provisions in terms of what they can and can't capture. So, look, I think there's a fair bit of law change being actively considered amongst jurisdictions. How much you'll trace back to the pandemic, I'm not sure, but the law won't stand still. I'm very confident of important changes over the next couple of years.
On that particular issue of reform, there's a question, does the ACCC plan to introduce any reforms relating to the current disruptive technological developments, privacy, online scam, online solicitation to buy goods and services, etc.?
Sorry, I missed the first bit of that.
Yes,
Justice
sorry.
Middleton.
Does the ACCC plan to introduce any reforms relating to the current disruptive technological developments, privacy, online scams, etc.?
Well, I think it's very much an issue for government as well. I mean, the government's asked us to look at a whole range of issues, which we've done. Now we're focusing very much on competition and consumer issues. But there is a review of privacy law going on by the Attorney General's Department, so that's something the government will be looking at. We're certainly looking at scam issues, and we're looking at misinformation issues. So I think this is, I mean, the really fascinating issue, which I think we can all have a view on, is how much you expect the platforms to self-regulate what happens on them versus how much government does that. And that's an issue I think government's slowly coming to grips with. You had, for example, the scams relating to various celebrities, if you remember Dick Smith, Andrew Forrest, and so forth. And the platforms are very slow to respond to those. So I think we will get change to privacy laws. I think the debate about whether it's self-regulation or government regulation of some of those other matters mentioned is an issue that's still unfolding. The journey's still got a fair way to go on that one. So I don't know where we'll go, but I know it'll be under active consideration.
All right. There are many questions, I should say, but I'm going to just, with time, just one last one. And the question is, are there any changes that could be made to the ACL to improve pricing transparency?
I don't know whether Neil wants to have a go at that one as well. Look, I think I guess my answer would be, and Neil might have a quick shot at it as well. My answer would be, the misleading and deceptive provisions, which are the essence of the ACL, do deal with a lot of the transparency issues. We've got a couple of cases in court in relation to the digital platforms, which I think illustrate that. My own view is that you can pick up other things under an unfair practices provision. I mean, I really prefer general provisions that apply across the economy rather than too many specific interventions. So I would hope we could deal with it under current provisions and unfair practices.
Do you want to add anything, Neil?
Only that the general provision of misleading conduct is often good enough to capture those cases where you have a headline price and then various hidden qualifications or additions to the price and that sort of thing. There's a fairly well-trodden path of saying that that kind of hidden qualification will often be inadequate to dispel the impressionistic effect of the headline price. So often general provisions, I think, work better, and you leave it to the courts to apply them to the particular fact situation.
Thank you. All right. Well, I think we'll have to now call it to a close. I would like to thank the organisers for this seminar and putting it all together, and also thank everybody. There's been a large number of people who are attending through Zoom. So thank you very much for joining us. We're fortunate indeed to have Mr. Rod Sims, the head of the ACCC, to give an insight into the future, as well as discussing the past 10 years. Equally, to have join us a senior experienced litigator, Neil Young, and a former federal court judge to give us insight to the litigation experience. So thank you very much for attending. We will now call an end to the session